Hello, everyone. Welcome back to our lecture series, wherein we will be discussing about recent landmark judgments. Today's discussion is going to be about the dichotomy that exists between our right to climate change from the adverse effect of climate change, and on the other side, our commitment towards the international platforms with respect to development that we aim to do. So, herein, we have one of the most prime cases of 2024, wherein the court has recognized a new set of right. Now, when I say new set of right, I am basically hinting that there was something which is interlinked or intertwined to this particular aspect, but not per se a declared right with respect to being free from the adverse effect of climate change. Okay, so I hope you've understood the context, and this is, as you see it on the screen, this is going to be our discussion for today's class, that is right to be free from the adverse effect of the climate change. Now the question that may come to your mind will be that, ma'am, we already have right to clean environment, we already have Article 48 in the Indian Constitution. We understand that we also have fundamental duties that we have enshrined towards and on ourselves as an individual for the protection of environment. Then is this different from these provisions that exist in the Indian Constitution? Or is the ambit of this particular aspect very similar to the same? So let's get into the facts, try to understand the facts as to what has motivated the court to come to this particular discussion. This story revolves around the bird called as Great Indian Bustard. Okay, so we have a species called as GIB that I'll be referring to in the discussion, that is the Great Indian Bustard, which was highlighted by various reports by various organizations that this is now coming to an extinction. And that is how the requirement and the need for the protection of GIB was highlighted in a petition by MK Ranjit Singh, in the case of MK Ranjit Singh versus Union of India. So, how do you remember the name of this case? You, as a judiciary aspirant, has so many judgments from the previous year. Then, how do we remember that this judgment relates to this topic? So, by the name of it, if you understand, he is a person who is a wildlife protectioner. He is a person who belongs to the arid area of Rajasthan. And because these birds are seen in Rajasthan, this motivated and this gave him an idea to reach to the court for the protection of this particular species. Okay, so that is how you can remember the name of Maharaja Kumar Ranjit Singh, who filed the petition to the Supreme Court. And now the court has reached to the discussion that we will have to keep in mind that every individual has a right to adverse effect from climate change and has to be given such protection. Okay, so these are multiple facts that these birds are usually seen in the inhabits dry grassy area of Rajasthan and Gujarat. Okay, so these are not birds that are easily available throughout and the other geographical area of India. These are rather restricted to the arid areas. And we will discuss, that how this is violating different other articles of Indian Constitution, but understanding that their existence is restricted to a particular geographical area. In addition to this, how with the development that we have introduced, different projects that we have introduced, their extinction is something that we can see in the coming days, right? And that is alarming also for us. So there is a severe threat of extinction as categorized by IUCN as well. And they highlighted and they understood that this is happening because of multiple factors. For example, the power lines. Now, there are power lines that are overhead. As to these birds, when they fly, they get injured because of these power lines. In addition to that, we also see that there is continuous development that is happening, and therefore the area in which they were found is now also getting reduced. So for them, to lay down their eggs, for them to go through the entire procedure of reproduction as well as for protection of their eggs is getting affected. And therefore this, this idea and this concept came into the mind of the applicant with respect to how this protection is required, and how the government is expected to work in favor of the protection of GIB. So we need certain order, we need certain judgment from the court to protect these particular GIBs. This was the mindset with which this particular writ petition was filed. So this is the background. Now when we go to the copy of the judgment, I'll just tell you that there is again an index that you will find, table of content that you will find in the judgment, wherein I have highlighted various aspects. Okay, so the judgment starts with the introduction of the bird, that is the great Indian bustard, and then it highlights and it takes us back to the previous judgment passed on 19th April 2021. So you will see that the previous judgment that was so passed was not sufficient. It provided a blanket immunity. It provided a blanket immunity with respect to the protection, yes, but at the same time, the different orders that were so passed were not really something that could be effectively executed. And therefore various ministries, various officers also wrote to the court now with respect to the hardships with in executing this particular judgment. We will understand that what were the different aspects of the judgment and what are the hardships with respect to their implementation. So that is covered under the second part of the judgment. Then the mission to combat climate change. Now we have to understand that we are trying and we are maintaining a balance between two aspects, that is our commitments at the international forums with respect to climate change and the protection from climate change. And we have various commitments by way of international conventions. So we will talk about Paris Agreement, we will talk about Kyoto Protocol, wherein we have committed that we are going to curb down the greenhouse effects, we are going to curb down the carbon emissions. And for all of this, we have different projects that we have introduced. Now, with the introduction of these projects, we see there is a conflict in the climate change and the development that may be happening. And in between, we see our great Indian bustards and their extinction and the reason for their extinction that that lies between these two primary grounds. Then we also have right to a healthy environment that is already recognized, but we say that these are two distinct rights. Okay, so from the table of content itself, you will understand that right to a healthy environment and the right to be free from the adverse effect of climate change. These are two distinct set of rights, and the court has very clearly highlighted and mentioned that there is requirement, there is need that we hold and we recognize this as a right today. Okay, then because of the 2021 judgment that was so passed, there was a requirement of removing the power lines that we had just discussed, right? And this, when being done, this is basically affecting the commitment towards the solar power. So if you have heard about the solar alliance that we have done internationally, right? Under that particular program, we promote the solar power to be generated, but at the same time, when you're doing so, you are putting power lines which is affecting the existence of the great Indian bustard. So how do we balance it? How do we bring a balance in these two conflicting provision is something that we have to discuss here. So that is why importance of solar power as a source of renewable energy is something that we will discuss, and then we will relate and understand it with the climate change litigation in other jurisdiction as it exists, and take those good ideas for the implementation of the present judgment. And the reason for the modification. So as clearly highlighted in the index itself. We have good enough reasons to modify the previous judgment, which is something that was also requested by various interlocutory application filed by different stakeholders in the given case. Okay, so from the previous judgment that was so passed, now we have various interlocutory applications that has come, which highlights and which says that please modify these orders and make them something possible for us to execute. So this is the outline of the judgment that we will be discussing today. Now comes the question. Let me just tell you that how is this discussion going to be helpful for you for your exam perspective. Okay. So firstly, if you have environment law specifically in your syllabus, this is going to be helpful for you because this is a landmark judgment. This is a recent judgment. It becomes very essential for you to cover it. Secondly, let's say this is not so, but you have essay writing in your exam. And anything with respect to sustainable development, with respect to protection of the environment, you definitely have to mention this recent judgment to upgrade your answer, to add quality to your answer. Okay, so this is going to be helpful for you as well. And thirdly, as a student of law, okay, this particular video will be seen by judiciary aspirants as well as student of law. You practice, or you are still studying, you continue to be a student of law, and that is why you must be upgraded and you must understand how we bring balance in case of a dichotomy of such a situation. Okay, so this is something that you can use, you can understand in your in reading of your other subjects as well. So this is going to be helpful for you also if you are a student of law. All right, now we have understood the facts very briefly. If I summarize, we understand that these birds are essential for us. Now the question comes, ma'am, why are we talking about these birds? How are they essential for our existence? So there are certain articles that we'll be discussing. For example, we relate the great Indian bustard and their existence and say that this is, if they extinct, or if there is a deterioration of their existence, it is going to be violative of Article 14. Now, how Article 14? Ma'am, Article 14 talks about right to equality. So how is equality getting affected because of the extinction of a particular bird? All right. So this all is related to basically climate change. Let me tell you how you relate. Firstly, we understand that we have a cycle in the nature which tells us that how we are going to balance the ecology. So to talk about ecological balance, we understand that we are going to have a cycle wherein one particular organism will consume the other will be consumed by another person, and accordingly the life cycle of this entire ecology remains balanced. Now to promote this, we understand that this entire cycle has to be balanced, right? It has to run in a way which the natural forces suggest. So if we bring any extortion, anything, any difference at any of the stages, we understand that it is going to affect the other class as well. So let's say when we talk about the existence of the smallest insect, do you think its existence and its extinction is going to affect the human being? Yes, it is going to do so. Okay, now let's say there is somebody who lives in an area called Lakshadweep, and we have somebody who lives in Maharashtra. Okay, or somebody who lives in MP. Now when I say MP, we are differing with respect to the geographical place. We are differing with respect to the natural resources available. This is entirely a landlocked state, right? So we understand that if there is going to be changes introduced in the ocean, the people living in Lakshadweep will be affected much more as compared to people living in the state of Madhya Pradesh, correct? We understand that their dependence on natural resources, for them, there is no Blinkit, there is no Zepto, which may be so available in the state of MP, right? So their dependency on the natural resources, be it the food that we're talking about, be it when you talk about the resources that they are referring to, that they are using for their existence. For example, fire may be of utmost importance for them, which may not be for a person living in MP, because he has LPG gas cylinders for cooking their food. So therefore, Article 14 comes into picture because we understand that here there is protection that is so required in their case, which has to be seen in a different manner as compared to the other places, right? So that is why Article 14 has to be seen in mind. There will definitely be violation of equality when you bring these imbalances in the ecological system. So that is why this judgment revolves under various constitutional provision and says that this has been touched and this has been violated when we do not try to protect the existence of any particular species. So rather than just understanding and rather than just restricting ourselves with respect to the existence of tigers, with respect to the existence of GIBs, we have to understand that their existence is important for them as well as for the entire society. Okay, so that is how the previous judgment has been criticized, wherein there were certain orders that were passed which we must see for us to understand that how they are not practically possible for them to implement, for the authorities to implement. So firstly, they said that we have to temporarily halt the construction of the overhead power lines. So there was a blanket order with respect to do not construct overhead power lines. Whatever has been constructed has to be changed. Whatever is about to be constructed has to be there has to be a halt that needs to be put on it. So this was this was a blanket order, and this is something which is going to cost a lot. So the pocket is going to be affected. And we also have to see that if we are actually changing them and we are burying these power lines to underground, then what is the practical possibility of it? There will be a lot of acquisition that will be required to be done. Are we prepared for that? There will be a lot of cutting of forest and green areas wherein you have to bury these power lines. Are we prepared for that? So simply passing an order, keeping in mind the great Indian bustard, but not the other aspects of the environment. So that is why this particular judgment of 2021 has been challenged again. It also suggested that we have to shift the power line in the critical areas of Buster to underground. So as I said, that we highlighted that this is a particular area where the GIBs usually locate, where they usually reproduce and lay their eggs and stay there for the protection of their eggs, right? So these are critical areas that we have identified. But is it really the entire area, or do we have to narrow it down? Is also a discussion that has been done in the present judgment. Then the installation of devices on the existing of the power line. So whatever power lines are there, we recommended that try to change them and make them underground. In addition to that, if not possible, then you put certain devices to prevent the bird collision. So the bird, when they are reaching, we can just maybe put an alarm, or certain devices was expected to be put on these power lines. So this still looks to some extent a workable idea, but all the other grounds look like something that is going to cost a lot on the pocket, as well as is going to be affecting the other stakeholders in the environment, and ecological balance is going to get affected. So that is why this aspect comes, that from the 2021 April order, there is going to be a dichotomy between the individuals as well as great Indian bustard. There is a dichotomy that is going to exist with respect to developing economy on one side and the ecological changes on the other. Now, when we talk about, let's say, Solar Alliance, right? When we talk about renewable resources, we are basically hinting and we are trying to promote, we are developing, right? We are developing with these green changes that we have promised at international forums for. But at the same time, we have to see that whether it is affecting our ecological changes or not, whether it is absolutely possible for us to make such transition or not. And that is why this discussion has been done in the present judgment. Okay. Now, the concerns or the issues, main issues in this particular case were that how do we protect the great Indian bustard? Firstly, that what can be the improvement on the previous judgment? Then, whether the order of the Supreme Court in 2021 restricting the overhead transmission lines needs reconsideration. So, as I told you, that the entire order with different aspects of land with respect to the transmission lines, all of this needs reconsideration or not is also something that will be answered here, and whether we require an expert committee to monitor and prepare data for protection of GIBs. So, as suggested, they had previously also recommended that you will need certain experts and their feedback and their data for the protection of GIB population. So, that is accordingly has been allowed also in the present judgment. Okay. Now, how Article 14, so I very briefly gave you an idea also that, when we talk about residents of certain region, okay, they are, when we talk about people living near the forest area, they already have disproportionate availability to these other resources that we may have, right? We have electricity all the time available, they may not have. So now they may not have water available all the time. So this entire division is very disproportionately managed, and accordingly we have to read it in context of Article 14 and provide this equality to every person with respect to access of these natural resources. So there are certain groups including indigenous and tribal communities, women, low income households. So the judgment basically also talks about women and low income household. As I said, low income household may not have LPG gas cylinder. As discussed in the judgment, they say that when we talk about women, we have to see that a woman who is working has lesser number of hours for devotion or for dedicating to the household chores, right? But on the other side, compared to a woman who's working in the tribal area or who's working in the forest area, she has other commitments. So we have to bring a balance between these different type of classification within the women itself, right? So these categorization that has been done, we have to keep in mind as to how we divide these natural resources. Whether we simply say that, okay, no solar plants to be established afterwards, is that going to affect a person living in the urban area, or is it going to affect the person living in the rural area? So these are certain examples with which you can relate as to how giving a blanket order or a blanket immunity would have affected different people. Then those residing in vulnerable geographical location and facing economic hardship, as I said, certain areas are more prone to earthquake or floods, and accordingly you have to keep the interest of those people also in mind while giving your judgment. Climate changes are not felt equally by everyone, and there is obviously unequal and disproportionate impact of climate change on certain communities. So, for example, when we talk about village jobs, you are creating village jobs by giving them, allowing them to use solar power plants. Now, this is also generating village jobs, right? So, is it not going to bring socio-economic benefits to those certain class of people? It will do so. It is going to reduce indoor air pollution and health risk. It is going to improvise the living standard. So these are all aspects related to development, but also related to climate change. We have to understand that how do we bring a balance between both these things, and accordingly lay down and decide whether something should be allowed or not. Then we talk about Article 21. So as I said, that the entire life cycle, when we talk about the ecological balance, it affects different people, right? It is going to affect different people in different manner. Like when we talk about AQI, why do you see Supreme Court being being very pro, and immediately they take action with respect to high AQI that we see in certain areas like Delhi? So that is done to protect and to bring balance in the society. We understand that the AQI is not that poor in when you go to northeast states as compared to Delhi. So the Honorable Supreme Court will always be very active actively protecting your rights, and that is what we are seeing here also happening. While at one aspect they are trying to protect the bird that is at the verge of extinction, at the same time they also have to see that the order that they pass for such protection is also not affecting the rights of different individuals. Okay, so as under Article 21, the judgment relates, and we say that this is for protection of endangered species, because if one species gets off the cycle, we understand that it is going to bring imbalance in the ecology. We also understand that there are environmental impacts that directly help affects the health of a person. So all these in its entirety can be understood, that how the judgment relates to Article 21. Then we have two set of duties. One is imposed on the state and the other one is imposed on the individual. So these are four provisions that you must remember, four articles that you must remember from Indian Constitution for the protection of wildlife, for the protection of environment and the living creatures. So when we talk about individuals, we have certain set of commitments, and at the same time the state has the duty to protect and improve the environment and safeguard forest and wildlife. So by this particular judgment, the court is basically going further and trying to improve the environment by safeguarding the forest and by safeguarding the wildlife, and GIBs belong to the same category. So this is in furtherance and this is in promotion of Article 48A of the Indian Constitution. Now, as I said that how do we bring a balance? How should we deciding this particular judgment, keeping in mind different aspect of it? So we have certain international commitments that we have made in different forums. For example, Kyoto Protocol, Paris Agreement. Herein we understand that we have made commitments with respect to renewable energies, greenhouse gas emissions, right? So there's a global shift towards cleaner fuels. There is a global shift towards moving towards renewable energy, and that will be done when we promote these concepts like solar energy, when we promote these concepts like reducing for example, introducing the idea of LPG and reducing the natural gases that are used, right? So promotion of, let's say, a gobar gas that we do. So all these are going to be promoting our commitments that we have made at international forums. But at the same time, you also have to understand that when we read this international commitment and their ideas in context of the 2021 rules, right, or the 2021 judgment, we understand that there is going to be hardships, right? Hardships, as I already told you, economic as well as practical implications with respect to converting these overhead transmissions into underground power lines. So you have committed, and now you have put a particular system, you have particular setup by which you promote these commitments, right? But at the same time, contrary to that, you are saying that we have to promote underground power lines. Now the underground power lines is not, will not be able to carry that high voltage as compared to the overhead power line. So is that not going to bring imbalance in the society? Is that not going to affect the pocket of people in the society? That is going to definitely get affected, right? So that is why it is said that when we plan to transition from non-fossil fuels to non-fossil fuels, we have to see that this is not merely a policy decision. Rather, this policy has to be seen in context of environment protection that is so there, right? So these are certain issues that were there with the previous judgment: safety risk, higher cost, technical impracticality. As I told you, it will not be able to transmit such high voltage. So these are technical impracticality that exist. Then there is the cost is such, which is way much higher, and at the same time there is safety risk that is so involved here. So to sum up, whatever we have discussed so far will be that we have understood that why GIBs and their existence is important for us, right? So we understand that GIB and their importance in the ecology, in the environment is required, and we have highlighted that. Then we understood the facts of the case as to how it was affected in various manners when we talk about their existence, when we talk about their growth, them reproducing, and them increasing in number is also not there. We understand that there are various predators that so exist. Okay, so if you do not provide fencing, if you do not provide a lot of protection to them, there was, these were also reasons like predators, as well as us encroaching their land where they lay down their eggs, are certain factors which has tried to, which has been the reason before the court for the extinction of the GIB. We refer to these set of facts, and then we refer to the previous judgment, by which we understood that there are certain risks that are so involved if we actually go by the implementation of the previous judgment. Then moving further, we understood certain provisions, different articles from the Indian Constitution, to understand that how the existence of a bird is going to affect your article 14, how the existence of a bird is going to affect your article 21, article 48A commitment, as well as 51A. So these are different provisions also that we have touched, that we have referred to understand the protection that is required to be given to the great Indian bustard. Now we come to that, how do we conclude and how do we actually try to find a midway? Okay, so let's go to the judgment, try to see that what is so recommended by the court. Now I'll tell you, if you are a judiciary aspirant, there are certain factors that you must refer to when you read a judgment. So if, let's say, a question comes in your exam wherein they ask you that what is the scientific name of great Indian bustard, if you have not read this judgment, you will feel that this is something which is not recent, this is something which has come from lucent. Okay, this is something which is very traditional that has been asked, something very scientific that has been asked. But you have to understand that every question that is so framed is framed keeping in mind, what are the recent developments also. So yes, this is a scientific name, but at the same time, this is something that has been touched by the Supreme Court in the recent time. So when you read the judgment, try to at least, glance through the important aspect of it. So the jurisdiction of Supreme Court has been invoked for protection of GIB. This is the scientific name of GIB. GIBs are found in these regions. There have been, extinction of GIB, that is a steady decline that we see in the population, and which has been so highlighted by IUCN. So you can expect a question on what is the full form of IUCN. You must know the structure of IUCN, who are the authorities leading IUCN, right? These are questions that you must immediately try to cover when you read a judgment, which is expected of you to know, because you are going to be judges. You must be aware about these things. Okay, so the classification has been so done. Then when we move ahead, I'll be reading and I'll be highlighting only the important aspects that I have already highlighted from my copy of judgment. Okay, so this is the previous judgment dated 19th April 2021. What were the challenges in this particular judgment? So there are, different. For example, we already understood the conversion that is to be done. I already told you that these are different respondents, ministries that have filed the interlocutory application and asked the court for modifying their previous judgment of 2021. Then we understand that we also have different commitments in the international forums, which we have highlighted before the court, telling the court that how whatever these ministries are doing, whatever these authorities are doing is already done, keeping in mind the international promises that we have made. Okay, then then these are reasons that we have mentioned over here as to why the reduction of great Indian bustard has really happened. So they have highlighted that first is that even before electrification this reduction started. Then why did it start? If not because of the power lines, that why was it happening? So they tell that because of the ecological imbalance that has been there, they have been poached by different other animals. Then they're talking about the reduction of the insects that exist in that particular area, which is consumed by the GIB. So lack of food also for them. And they also then talk about the carbon footprint and our international commitments with respect to solar installation, reduction of carbon footprint, as well as to promote renewable sources. So these are different aspects from the has been discussed. by the different stakeholders in the given case. Okay, I'll not be repeating all of this. I'll anyway have given you an idea and brief about this. Okay, now this is an important aspect because we understand that here we have made a distinct, we have made a headline with two distinct particular rights. One is right to healthy environment, and the other is right to be free from the adverse effect of climate change. So again, time and again, I've told you that these are highlighted at two different set of rights that we recognize by way of this judgment. This is a particular right which has, which has been highlighted by the court previously also in case of MT Mehta, Kamalnath case, right? We have multiple judgments that have been quoted here also, different precedents with respect to the protection of right to a healthy environment enshrined and recognized under Article 21 of the Indian Constitution. Then comes the question with regards to right to be free from the adverse effect of climate change. So how do we recognize that? Let's talk about this. So if you see, I have highlighted this entire discussion is going around right to healthy environment. We have spoken about MC Mehta versus Kamalnath. This is one of the landmark judgment which covers the idea of polluter pays principle, as well as very important, the public trust. Okay, the concept of public trust or trust that so exists in the protection of environment. So you must know this case if you are preparing for judiciary. Okay, then this is the important paragraph that I have highlighted over here. We must read this to understand the title of this particular case that we are discussing, to understand the underlying idea of this particular judgment. Okay, so I'll just highlight and read with you. Despite a plethora of decisions on the right to clean environment, as we understood, some decisions which recognize climate change as a serious threat and national policies which seek to combat climate change, it is yet to be articulated that the people have a right against the adverse effect of climate change. So we have understood that it is yet to be decided, it is yet to be highlighted that we have a distinct right, and that right is of every individual against the adverse effect of climate change. Okay, this is perhaps because this right may look or may appear to be the two sides of the same coin, but as the havoc is increasing year by year, it is important and it is necessary that we articulate this as a distinct right and recognize it under Article 14 and 21. So this is something that we had discussed also when we spoke about 21 and 14, that there is a requirement now when we take these policy decisions, when we make these international commitments, we keep in mind that in addition to right to healthy environment, we also have a right against the adverse effect of climate change. Okay, so now this entire discussion goes on in the judgment as to how Article 14 and 21 will be affected when we do not protect the environment. Okay, this is something that we have done already. Now I'll take you to the conclusion part. I will also expect and I will request you to read these reasons of modification, because this will give you clarity as to what all were the different factors. We have paucity of time, we have covered up, we have covered a brief of it as to there was financial restraint, we understand that there is impracticality, we understand that it is going to affect our promises made at international forum. I've given you the summary of it, but if time allows, try to read the judgment also of the same. So if you see this, this is for example, is going to cost 5 times more to us if we start making these power lines, or if we start changing these power lines and underground them. Then I told you about acquisition of property also is going to be an important aspect. How do you acquire so much of property for you to pass these underground power lines is also going to be a question, and a lot of stakeholders are involved there as well. So that is why when you read a judgment, you have to read in its entirety for you to have clarity. One is wherein, in 10 minutes, I give you a summary of the judgment that is, of course, available to us. But when you're preparing for judiciary, when you are actually preparing for a competitive exam, when you are a student of law and you are in the process of learning how to read law, it becomes important for you to get used to the habit of reading these judgment understanding the different arguments laid down, understanding how we bring the balance between the argument, how do we decide a particular case in a particular manner, is is something that will come naturally to you when you start when you begin with this practice of reading the whole judgment. Okay, so and you can restrict, obviously, if you are not preparing for judiciary and you're merely a student of law, you can definitely restrict to your area of research. But if you are preparing for judiciary, then you definitely have to do this. And do not worry if you do not have time, you feel that we already have so much to study, ma'am, we have bns now, all these changed laws that have been introduced, then we are here at LiveLaw Academy. Our motive and our intention to do and to run these lectures is for us to cover these judgments for you. If you devote your 1 hour, you devote your 50 minutes or 40 minutes with us, we cover the judgment in its entirety. If you get a problem based question, if you get a theoretical question, if you get MCQ, I hope this particular video will benefit you in answering those questions in your exam. So, and as I already told you in the previous class also, feel free to drop your comment in the comment box. Let us know if you want us to cover any other judgment in addition to what we are already doing. We'll be more than happy to cover those cases in depth and analyze those cases with you over here. Okay, yes. Now moving further, I always recommend this to my students also, that whenever, if there is paucity of time, at least try to go through these conclusion or the remarks that are so made in the judgment. Okay, so these are certain grounds by which we understand. So all these grounds that are there from A to J, all this will be summary for you to summarize as to what we have understood today. So let me just read out a few points for you. For example, the first one, the ministry, all these ministries that are so named, has implemented the national GIB project, which undertakes ex situ conservation measures to provide conserve habitats into which captive birds may be released. Insulation breeding centers will be established. So this is something that how do we actually execute the order done. So one aspect of the judgment is wherein we say that you have to make these breeding centers for them. Okay, there are recommendations made to the Indian Army also, because they so exist there, and according to that we are saying that we have to insulate these breeding centers, we have to prepare these breeding centers for the GIBs, for them to reproduce, for them to feel protected when they are in that particular procedure. Okay, this has been highlighted also by the petitioner in the case, that how it takes only one egg is laid by these birds, and how they are in continuous anxiety when till the bird actually uh, comes out of the egg. So this is why this particular measure has been taken. So you see, the argument takes us to the conclusion and for the solution to be given by the court. Then we will take one more. Okay, undesirable and invasive species will be eliminated to make the grassland more friendly. So now, because we saw that the grassland has been reducing, if you see, there are various projects that have been introduced in state of Rajasthan, Gujarat, wherein you see that we are promoting and we are trying to restore the grassland. The grassland's existence is important for GIBs. GIB's existence is important for individuals like us and other animals, right? So that is why we say that firstly, we have to restore the grassland. Secondly, we have to ensure that there is no species that invades into these grasslands, into these areas, and affects the procedure of the laying of eggs of the GIB. So that is also something that have been done. Then we speak of National Bustard Day that has been decided. So please, if you have attended this lecture so far with me, drop the comment in the comment box and let me know and let others know as to what is the day decided for celebrating the National Bustard Day. Okay, do let us know in the chat box. Okay, then I go to the last one, that the conservation activities detailed above will be upscaled from the financial year. So we have already decided that we have to go ahead with the new judgment. We have to ensure that the previous judgment stands substituted and the new directions have to be accordingly followed by the court. So this is the judgment, this is the idea of this particular case, which is MK Ranjit Singh versus Union of India, decided in 2024, covers these precedents that I have mentioned over here, and acknowledges a right to be free from the adverse effect of climate change as a distinct right, keeping in mind the ecological balance that we are required to do in addition to the protection that is already there, that is right to a healthy environment. So I hope this class was beneficial. I hope that you feel that you have learned something new, and this is added to your knowledge. Now again, I'll be reiterating and I'll be expecting you to drop a comment if you have any doubt, as well as drop a comment if you want us to cover any particular judgment. Thank you, each one of you, and I'll see you next again with another landmark judgment.